Hi guys, welcome back. My name is Sakshi Kaushik and today I am going to discuss a very interesting topic, that is right to constitutional remedies. Now this is one of my favorite topic. The reason being, when we are guaranteed certain fundamental rights, so there is one mechanism for their enforceability. Yani ki if I say that I have right to life and personal liberty, and if the state is not making me exercise my right to life and personal liberty, so what is the remedy I do have against the state? So वही remedy आज हम writs की form में discuss करने वाले हैं. As you all know, part 3 of the constitution, it talks about the fundamental rights. It says article 12 से लेकर article 35 तक the all rights are fundamental rights, and the best thing is that the enforceability of fundamental rights is itself a fundamental right. Why I'm saying this? Because article 32 talks about right to constitutional remedies. Now this article 32 is itself a part of the fundamental right, and part 3 of the constitution is enforceable in nature. So in this video, I am going to discuss the certain types of writs. Writs क्या है? It is a form of order which is issued by the court to a particular person or authority to exercise the particular thing. यानी कि किसी ने अगर मेरा fundamental right violate किया है, so that person will be issued a writ, and that is a form of order which will be issued by the court. अब एनफोर्सेबिलिटी ऑफ फंडामेंटल राइट्स की चार जगह बात होती है कॉन्स्टिट्यूशन में. द फर्स्ट इज आर्टिकल 13, इट इज जुडिशियल रिव्यू. Secondly, Article 359, it says that all fundamental rights may be taken away from us except Article 20 and 21 during the imposition of national emergency in the country. यानी कि कोई भी fundamental right state हमसे ले सकती है, but except Article 20 and 21, because they are the basic inherited rights given to all people of the country. Third is Article 32. As I told you, it is right to constitutional remedies and it is enforceable in Supreme Court. In the same way, power is given to High Court also, which is given under Article 226. So in this video, I am going to discuss the writs which is issued by the Supreme Court and High Court wherever aggrieved person is approaching. If I say Article 32, तो 32 बात करता है enforceability in Supreme Court, and when I say 226, so enforceability होगी High Court में. Mind it, you can directly approach to Supreme Court for the enforceability of fundamental right, but the Supreme Court may question you कि आप पहले High Court में क्यों नहीं गए, but they cannot refuse you for enforcing your fundamental right. One major difference between Article 32 and 226 is that Article 32 is itself a fundamental right, but 226 is not a fundamental right, but the High Court may issue certain writs to the concerned person or authority. The major difference जो इसमें देखा जाता है वो ये है, Article 226 is a broad one as compared to Article 32. Because under Article 226, the High Court is granted with two types of rights. One is the enforceability of fundamental right, and second is for the enforceability of other legal rights. The difference is fundamental right की situation में High Court मना नहीं कर सकता, but the other rights I'm referring, the other legal rights, it is at the discretion of the High Court whether to enforce it or not. So that is the reason we say that 226 is a broader one and 32 is narrow in comparison to both of the articles. So let's discuss different types of writs. There are 5 types of writs which is being talked about in Article 32 and 226. 5 types की writs हैं: habeas corpus, mandamus, certiorari, prohibition and quo warranto. We are going to discuss this one by one. सबसे पहले है habeas corpus. Now this is a Latin word which means you may have the body. If any person is illegally detained by the state or an individual, the remedy is to approach the Supreme Court, and the Supreme Court will issue a certain form of writ in the form of order to basically ask the authority or the person to release that person. इसको एग्जाम्पल से समझते हैं। मान लीजिए एक पर्सन को पनिशमेंट होनी थी 3 साल की, बट जेल अथॉरिटीज ने उसको अगले 3 साल के लिए और रख लिया, यानी कि 3+3। नाउ दैट कंसर्न पर्सन हिमसेल्फ or any of his relative or neighbor can approach the court for the prevention of illegal detention of that person, because 3 साल का राइट था बट उसको 3 से ज्यादा रखा है, सो वो उसका इलीगल डिटेंशन हुआ है। सो बेसिकली habeas corpus can be exercised against state as well as against an individual to prevent any person from the illegal detention. कुछ सेफगार्ड्स दिए हैं आर्टिकल 22 में। वन ऑफ द सेफगार्ड इज दैट विद इन 24 आवर्स ऑफ द अरेस्ट द मैजिस्ट्रेट will be seeing that particular accused. That means the police has to present the accused in front of the magistrate within 24 hours. अगर पुलिस 24 आवर्स में मैजिस्ट्रेट के सामने accused को प्रेजेंट नहीं करेगी, so accused himself or any concerned person with him can approach the court for the illegal detention. So basically this is about the habeas corpus. Second है Q warranto. It means what is your authority? If any person is holding any public office and that person is found to be ineligible for that, so in that situation Supreme Court उस person को writ issue करेगा that by what authority you are holding this office. For example, if a person becomes an IAS officer, so it is assumed that he is a graduate, but बाद में ये पता चलता है that the person is not a graduate. So in that situation, the court may issue a writ of Q warranto against him that you are holding a public office and by what authority you are holding this office. Basically, the purpose of Q warranto is to prevent illegal usurpation of public office by an individual. कि कोई भी individual public office का misuse ना कर सके. Third is mandamus. Mandamus means we command. That means आप किसी public office में गए, आपने किसी काम के लिए उनको बोला, but they refuse to perform it. एक example से समझते हैं। आप म्यूनिसिपैलिटी के पास गए, आपने बोला आपका काम है to clean the street, and they refused to do so. Although it was their duty to do so, but they refused. So in that situation, what is the remedy that you have? That you can go to the Supreme Court or the High Court for the enforceability of your fundamental right, that you have a right to stay in a clean environment and the municipality is not doing their work. So in this situation, the court will issue a writ of mandamus against the municipality and mandamus के अंदर municipality को अपना काम अब करना पड़ेगा. अब mandamus it can be issued against administrative, legislative, क्वाज़ी जुडिशियल और एनी जुडिशियल बॉडी, यानी कि किसी भी बॉडी के अगेंस्ट मैंडेमस इशू हो सकता है इफ यू हैव आस्क्ड देम समथिंग एंड दे हैव रिफ्यूज्ड टू परफॉर्म इट. फोर्थ इज सर्शोरी एंड प्रोहिबिशन. नाउ दिस इज समवेयर सिमिलर. सर्शोरी और प्रोहिबिशन में सिर्फ एक डिफरेंस आता है, वो है डिफरेंट स्टेजेस का, कि सर्शोरी किस स्टेज पर इशू होगा एंड प्रोहिबिशन किस स्टेज पर इशू होगा. पहले ये देखते हैं सर्शोरी है क्या. Certiorari means to be informed. In this situation, what happened? The higher court issue a writ to the inferior court or tribunal or authority to quash the judgment. यानी कि certiorari में उनके पास right नहीं था, but then also they have given a particular judgment. अब उस judgment को quash करने के लिए certiorari की writ issue करेगा Supreme Court या High Court. And prohibition में क्या होगा? प्रोहिबिशन में 4 पॉइंट्स हैं जिस सिचुएशन में कोर्ट इंफीरियर कोर्ट को इशू करेगा प्रोहिबिशन. प्रोहिबिशन मींस टू प्रोहिबिट. इट कैन बी इशूड, चलिए स्क्रीन पे देखते हैं. प्रोसीड टू एक्ट विदाउट जुरिस्डिक्शन और इन एक्सेस ऑफ जुरिस्डिक्शन, या तो है ही नहीं जुरिस्डिक्शन या एक्सेस ऑफ जुरिस्डिक्शन में किया है. सेकेंड, दैट द कोर्ट हैज वायलेटेड द रूल्स ऑफ नेचुरल जस्टिस. थर्ड इज दैट दे हैव प्रोसीडेड टू एक्ट अंडर अ लॉ which is itself unconstitutional. Or D, that is the fourth point, proceed to act in contravention of fundamental right. यानी कि ऐसा कुछ कोई काम किया है which is in contravention with fundamental right. Now the most important thing, that is the difference between certiorari and prohibition, is the stages. अब मान लीजिए एक कोर्ट ने जजमेंट दे दिया, तो वो क्या होगा, अब कोर्ट क्या करेगा उसके अगेंस्ट? certiorari इशू करेगा, बिकॉज उन्होंने जजमेंट दे दिया है and to quash the judgment, the writ of certiorari is issued. प्रोहिबिशन का सिंपल मीनिंग क्या है? टू प्रोहिबिट. अभी उन्होंने डिसीजन दिया नहीं है, दे आर कंटिन्यूइंग प्रोसीडिंग्स, बट within the proceedings they have been stopped, they have been prohibited, so that means prohibition will be issued against them. I hope this is clear to all that जब जजमेंट आ चुका है तो क्या इशू होगा? certiorari to quash its judgment. जब डिसीजन नहीं आया है, दे आर बेसिकली कैरिंग ऑन द प्रोसीडिंग. विद इन प्रोसीडिंग अगर उनको प्रोहिबिट किया जाता है, सो दैट इज prohibition. So majorly that was about the writs under Article 32. I hope this is clear to all of you. Thank you so much.